Tuesday, May 13th, 2025. Adequate notice of this meeting was provided in accordance with the Open Public Meetings Act, NJSA:4-6, specifically on January 15th, 2025. Proper notice was sent to the Courier News and the Star Ledger and filed with the clerk at the Township of Bridgewater and posted on the Municipal Bulletin Board. Please be aware of the Zoning Board adjustment policy for public hearings. No new applications will be heard after 9:30 p.m. and no new testimony will be taken after 10. If you're able, please rise for the salute to the flag.
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Good evening. If we could have a roll call, please.
Mr. Wydell?
Here.
Mr. Sweeney? Mr. Amin? Mr. Amin, sorry. Mr. Fresco?
Here.
Mr. Bongiorno? Mr. Gajewski? Mr. Seacat? Mr. Kulak?
Here.
Mr. Vesio?
Here.
Mr. Gabbett?
Here.
And Chairman Foose.
Here.
Oh, and also I should Mr. Aller?
I'm here.
Mrs. Samard? And Mr. Burr.
Here.
Thank you.
Great. Thank you very much. We're going to open up the meeting to members of the public that would like to speak on any land use issue which is not on our agenda tonight. You can come on forward and use the microphone. Seeing none, I'm going to close that portion. We've got some minutes for approval. We have the February 11th, the March 25th, and April 8th from 2025. Let's take them each to go oldest first. February 11th, 2025. Comments, changes, please.
The first one,
Yes.
February 11th?
Yes. What do you got?
Okay. I think I'm fine with it.
Okay. Give a motion, please.
I move.
Mr. Widley, do I have a second, please?
Second.
Oh, it's Mr. Fresco.
Mr. Whiteley?
Yes.
Mrs. Amin?
Yes.
Mr. Fresco?
Yes. Yes.
Mr. Seacat?
I'm sorry, I just walked in and I'm not exactly sure what we're voting for, so I don't know if I...
Voting on the February 11th minutes.
Yeah, yes.
Mr. Kulak?
Yes.
Mr. Vesio?
Yes.
Mr. Gabbett?
Yes.
And Chairman Foose.
Yes. All right, next up, March 25th, 2025. Comments or changes, please?
On page 2, when we go to the resolutions, it says yes, right? By all 11 members are yes. So I said Mr. Sarakat, Kulak, Rescue, and Gabbard should move to ineligible.
Ineligible.
Ineligible, because you can't have all 11 members voting. Yes.
Rich?
So there would only be 7 yes votes or 7 votes in total.
Gotcha.
Right? So those would be the only 7 to show.
So members 8 through 11 would go to ineligible?
I wouldn't list them as ineligible either. I would just show the yeses. Right? They're the only ones that are.
Gotcha. So we're going to strike members 8 from 11 under the yeses.
Yeah. Just
Got it.
those 7.
All right, how about the next application, 24-011?
Okay, the next one is fine because there are 1, 2, 3, 4 people who are not voting, ineligible, right?
Yeah. Yeah, and then there's 7 up there. 1, 2, 3,
Yeah.
4, 5, 6, 7.
So
That's
the
fine.
next one is fine. That's a change.
A motion, please, with the changes.
I move.
A second?
I second.
All right, Mrs. Amin's the second, so it's Badelli and Amin.
for March 25th?
That's correct.
Mr. Whiteley?
Yes.
Mrs. Amin?
Yes,
Mr. Fresco?
Yes.
Mr. Seacat?
Yes.
Mr. Kulak?
Yes.
Mr. Vesio?
Yes.
Mr. Gabbett?
Yes.
And Chairman Foose.
Yes. Okay, last up, we have April 8th, 2025. Comments or changes to the minutes, please?
okay. Same thing,
Same thing?
Page 2, you know,
Okay, we'll carry forward the 7 affirmative votes.
7 names are there for yes vote. right?
Okay, we'll make those changes.
Ineligible should be put in there, their names should be, because they're present,
Yeah,
They're all
that's fine.
present.
You can list them that way.
Okay.
the remaining 4, which you
Yep,
can,
no, he's got them, right. So, not voting then were Sikat, Kulak, Vesio, and Gabbett.
be ineligible
Okay,
in both places, in 2 places.
Gotcha.
There and here.
So the next one.
on page 2.
Yes.
Right.
Okay. Anything else?
Sorry, what was the correction?
I'll give you a copy of this, okay?
Okay.
Have a motion, please, with the changes.
I move with the changes.
All right, do you have a second, please?
Second,
Mrs. Amin's the second.
Mr. Whiteley?
Yes.
Mr. Sween, I'm sorry. Mrs. Amin?
yes,
Mr. Fresco?
Yes.
Mr. Seacat?
Yes.
Mr. Kulak?
Yes.
Mr. Vesio?
Yes.
Mr. Gabbett?
Yes.
And Chairman Foose.
Yes. All right, next up, we have 2 resolutions. Let's do Visions and Pathways first. And anyone that doesn't have it, there's a copy, hard copy on the dais for you.
So there were a couple of, just as you're looking at it, there's a couple of small changes at page 3, paragraph 6, 1, 2, 3, 4, 5, 6, 7 lines down, should say each resident will pay 30% of their income, not 10. And then also at page 12, the whereas paragraph should refer back to April 8th, 2025, not May 13th.
this, and then the other one.
Anyone else? Visions and Pathways? Can I get a nomination with the changes, please?
I move with the changes.
All right. Second?
Second.
All right, Mr. Fresco, second. It was Whiteley and Fresco.
Thank you. Mr. Whiteley?
Yes.
Mrs. Amin?
Yes,
Mr. Fresco?
Yes.
Mr. Seacat?
Yes.
And Chairman Foose.
Yes. All right, next up, we have
I'm
750.
sorry, but I think Mr. Seacat
Seacat's
was
not eligible.
voting on that. Bongiorno?
I thought Mr. Sweeney was absent that day, so Mr. Seacat voted.
I have. Is that what happened? Sorry, who did you think was absent?
Sweeney.
I don't think he was here at the last meeting.
Okay, so Sweeney's absent. Okay. And Mr. Seacat will be voting.
And you were a yes, right, Mr. Seacat?
Yes.
All right.
Maria had it right.
That sounds 7 to me.
Okay.
All right. Next up, 756 Wingate Drive. It's a residential. Comments or changes?
So there is one on page 3. That paragraph references, paragraph 9 references Mr. Grutzmacher in 2 places. It should be referencing Mr. Fortune instead.
Any other changes? Have a motion with the changes, please?
I move with the change.
Mr. Whiteley, second, please.
yes, second,
Mrs. Amin, is there a second?
Mr. Whiteley?
Yes.
Mrs. Amin?
yes,
Mr. Fresco?
Yes.
And Chairman Foose.
Yes. All right, moving on to our land development applications. We have 2 cases tonight. First up is going to be a residential case. 859 Brown Road. Come on forward. Check notice and swear them in.
So I did review the notice on this application. It was in proper form. It was published timely and served timely by certified mail. So the board does have jurisdiction over the application.
Mr. Chairman, Dave Stiers. I'm representing the client, Mr. Yu. He is here tonight. We don't have an attorney. I thought he was hiring one, but he hired one just for the notification, and so I'm standing in. I'm a consulting engineer and planner in the state of New Jersey.
I'm told the microphone, handheld works. I know.
Microphone.
Yeah.
Yeah, and Mr. Stiers, let me just swear you in first, too. Would you just raise your right hand?
The red light? Got it, okay, thanks.
You solemnly swear that the testimony you will give to this board will be the truth, the whole truth, and nothing but the truth, so.
I do.
And again, Mr. Stiers has been before the board.
Mr. Stiers knows his way around this room.
Yeah.
And you're an
Appreciate it.
attorney by now, too, right?
No.
No?
No. No, thank you. All right. So the application is for 859 Brown Road. It's for a lot coverage variance for a patio in the rear of the single-family home. So the property is located, if you come in off of 202, 206 past Hillside School, and you kind of enter that bend there going up the hill, he's just to the property is just to the left. The property is severely sloping. There's about 140 feet of elevation change from Brown Road up to the back of the property. And as such, the Hillside Development Ordinance severely reduces the amount of buildable area. So by way of history, Mr. Yu, a year and a half ago, unbeknownst to him, he required a permit to take a deck down and he was replacing that with a patio, and in Bridgewater Township, decks don't count towards lot coverage, but patios do. So we exceeded the allowable lot coverage. Just for a bit of history, the lot is 59,535 square feet. It's in the R50 zone, and based on the Hillside Development Ordinances, the buildable area is then reduced to 8,760, and then the improved lot coverage is 18% of that, and that takes you down to 1,577 square feet. So in my opinion, as a professional engineer, you can't really build a single-family house and the associated site improvements with that kind of square footage. So there was a couple questions in the report from the the board planner and board engineer. One had to do with the size of the proposed patio. The patio is actually smaller than what the deck was. We have some prior surveys, and the patio is roughly 25 by 15, and the former deck was 35 by 15. Another comment arose relative to the location of the retaining wall. The retaining wall was also replaced when they improved the patio, which is behind the single-family house, and that stone wall was basically replaced in kind. And I think what Mr. Yu did was he added a little bit of stone behind that wall in an effort to redirect some of the runoff away from the back of the house and around the sides of the house. I think, in my professional opinion, I think it's a hardship variance. The Hillside Development Ordinance severely restricts the amount of developable property. I don't think the plans as presented are extravagant in any way. It's a relatively small patio. The deck was actually bigger, as I testified, and from a point of view relative to the surrounding property owners, the deck and the patio are virtually the same in appearance and consistent with single-family living.
David, were there safety considerations here that led to them taking action before they had all the necessary paperwork done?
He did talk about There was rotted deck planks that needed to be replaced, so yeah, I would consider that a safety issue.
Okay. And has an engineer looked at the retaining wall that's in there? Because when you drive by, your view from the street is you can see the retaining wall. It's quite a slope it's holding back.
It runs from 2 to about 4 feet.
Yeah.
And he does have a large amount of clean stone behind it, so
Right.
the water runs down and then I guess around either side of the retaining wall.
So in your professional opinion, it's safe?
I would say it's safe, and typically anything under 4 feet doesn't require building permits because of the height.
Just straight up, the mountain that's kind of
Oh,
holding back?
yeah. Like I said, 140 feet from the brown all the way up.
Could you give just a little bit of testimony on if this was a flat lot, what the relief needed would be, if any?
There would be no relief. There's 18% allowable coverage if it was a flat lot. Before the patio was installed, it was at 6.81, and we're at 7.78, so less than 50% of what would be allowed if it was a flat lot.
And in terms of hillside development, the ordinance itself, I just like to put this on the record each time. It's designed to protect tree canopy when people are looking up at a hillside. Was the tree canopy affected in any way in this case?
No, it was not, and that's a good point. The other thing, and I represent the board in Watchung, and we see a lot of these as well, and a lot of consideration is taken by the board as to where the proposed improvements are going, and this was in the 0 to 10%. It was not in the severe slopes, and again, like you said, there were no trees impacted by the swap from the patio, from the deck to the patio.
I don't think it said in the memo. I'm referencing the May 7, 2025 Board Professionals memo. What variance relief is required here? Is that a D variance?
Page 4.
Page 4?
It's just,
It's a C?
yeah, it's just the max improved coverage.
Gotcha. All right. All right. Board questions? Board professionals?
Just two quick questions, Mr. Chairman. So Dave, I think I heard your testimony was in replacing the wall and replacing the deck with a patio, there was no plus 30% slopes disturbed, everything was contained within the 0 to 10?
Yes, and the wall was right up against that 30%, but my client replaced it in the same location.
same
So there
location.
may have been a little bit of impact to put that stone behind it.
Okay. And from a drainage perspective, from converting from a deck to a patio, any negative impacts to the adjacent properties, the downhill properties?
No, it's a small increase, and I believe a majority of it would be going from that wall towards the southeast, so out towards Brown and away from the neighbors.
Thank you.
Thank you. I don't know if it came up in the memo or came across in the memo. I just asked for a quick kind of summary of how the variance became, I became notified that there was a variance on the property, how we ended up here at the board.
I believe he had subsequent to the installation of the patio, he did have a zoning violation issued, and then they hired us. We examined the property and then found the lot coverage issue.
Thank you. And I think, this is an extreme case of the hillside development calculations. I think it's an incredible ordinance provision. I think it does its job in most cases. I legitimately texted Bill and I was like, I think I'm calculating the hillside development calculations wrong here because it does have such an impact on this lot. This is an absolutely extreme case of that. It's the reason why the variance is there. You asked a very good question about would they need a variance if it was a flat lot? Absolutely not.
I love the hillside development ordinance. I think it's important, but this is, kind of the roadkill of it. This is the unfortunate consequence of it, and I feel bad when residents get caught up in it, but we want to protect our trees, we want to protect our hilly landscapes, Watchung uses as well.
Yeah,
and
the water running down the hills.
Beautiful area you want to protect. So, all right, members of the public, questions on Mr. Steyer's testimony? All right, seeing none, you want to just wrap it up?
I'm not an attorney, but we would request a positive outcome from the board and for consideration for the variance.
All right. And as Rich mentioned, it is a C variance.
It's a C1, yes, and there's no other conditions other than our normal conditions.
Do you feel that the threshold of testimony for a hardship-type variance was given for a C1?
I do, in light of the steep slope that the applicant has and the reduced building area that it results in.
All right, very good. Then let's open up to members of the public that would like to speak for or against this case. Now's the time to approach, make your comments. Seeing none, we're going to close that portion. And Mr. Stiers, thank you. We're going to open up for deliberations if you're
Thank you.
okay with that.
Yes.
All right, great. Let's start down to Mr. Gavitt. Good evening, sir. Your thoughts?
Good evening. Yeah, that area, it's hard to do anything in the back because of the slopes. To the point several people have raised now, if it was a flat lot, there would be nothing needed. I don't think anything was harmed by this. I think it's a reasonable request. I'd be in favor.
Thank you very much. Mr. Kulak.
I would agree as well, and I think there's very minimal impact, plus we're really trading the deck for the patio, so we're not increasing anything except under the technicality of our own ordinances, because we don't count decks and we do count patios. But I think this won't do any harm, and I think we should approve it.
Thank you. Mr. Seacat.
Yes, I also agree, minimal impact, and I understand the hardship. I would support the application.
Thank you. Jim.
I have no problem. I'm all for it.
Mr. Vesio, good evening.
Yeah,
Mrs. Amin.
it's a simple variance, and it's because of this steep slope, and I'm in favor of approving.
Mr. Fresco.
Yeah, I'm fine with it. I agree with everybody.
Thank you. Mr. Vesio.
Yeah, I'm for approving this variance. It's an existing lot with this existing steep slope condition. You know, sometimes, there's not one size that fits all in this case, and I'm okay with this variance.
Thank you. I'm in favor as well, and with that,
I'll give a motion, yes.
all right, Mr. Waddell's the motion. Do I have a second, please? Mrs. Amin, your second? Thank you.
Mr. Wydell?
Yes.
Mrs. Amin?
Yes,
Mr. Fresco?
Yes.
Mr. Seacat?
Yes.
Mr. Kulak?
Yes.
Mr. Vesio?
Yes.
And Chairman Foose.
Yes. All right. Thank you, David. Thank you, Mr. Yu. Good luck. All right. Next case. Germunk Oil, 24 Finderen Avenue. Everything's got to be on a microphone. We've got to.
Matter which one?
It doesn't matter which one.
Yeah, this one, this one.
Hi.
Good evening.
So before we even jump in, you have a tank on your property. I was there today. It says it's stamped 275 gallons, and I don't even want to put anything official into the record. It happened to be just coincidental. Mr. Burr, our township engineer, the hardest working man in the township, was there. Bill, why don't you tell the board and the applicant and the attorney what you saw? And keep in mind, we're going to reference a letter from our zoning officer. I think it was point number 5 that mentioned these criteria that needed to be satisfied before this hearing was to take place. It's the last bullet point. And one of those points mentioned is a safe environmental and an operating condition.
Well, just so we're clear, Mr. Chairman, the zoning violation after number, it does list 5 particular points, and then thereafter says property owner has responsibility to maintain the site clean, safe, and sanitary condition.
So I want to talk about the safe condition, and I want to talk about the tank that was stamped at 275 gallons, and I'll hand it off to you.
Yeah, Mr. Chairman, I did happen to visit the site at the same time that you did. As a coincidence today, I was looking through my notes from the March meeting, and there was a commitment to actually visit the site by me and report back to the board at this meeting. Better late than never, but I was out there and made a few observations. It did look like a new fence was installed around the location of where the building is proposed. So there was a chain link fence installed, and the previously installed rebar was capped, so you no longer had the exposed rebar. What I did notice, though, two things stuck out to me. One is the lawn was still largely unkept. It looked like it hadn't been mowed in a few weeks, and I know that that was an issue, number 5, that was raised on the zoning officer's violation from January. The other issue that I noticed that wasn't raised was, it looks like there is a spill containment tank. Almost, when I first saw it, it looked to me like a tank that's usually used for storing pesticides. It's in the lawn area, adjacent or behind the fueling station along 3rd Ave. And it struck me as odd being in the lawn area. I don't know if what that tank is being used for is the way it should be used for spill containment, and I suspect we're going to hear from the applicant about that. But I was not excited about the location of it, for lack of a better word. If it's used for spill containment, it shouldn't be in the lawn area.
Bill, did that containment have a valve at the bottom?
It did have a valve at the bottom, for sure, Mr. Chairman. It
Could a valve?
closed condition, but I can't speak if it's leaking or not.
Okay.
Yes. And it was the tank, 275 gallons. It was about half full with fluids. And as I understand, it's when, if there are small overflows or et cetera during the major refueling operations, that's used, as a secondary containment. So I think there needs to be a discussion on that. But those were really the two issues that I happened to notice, was that tank and then the unkept nature of the lawn area and, just generally the site as a whole.
Yeah.
I will mention, though, a short while ago, actually, Maria showed me that the township zoning officer texted Maria and said most, if not all, of the issues on his prior violation have been addressed, but he didn't have a chance to issue anything in writing in advance of the meeting. So, I think I can agree that several of these issues have been addressed, but you still have the lawn and that storage tank.
Right, well, I do recall the March meeting very clearly. I did ask the tank to be moved. I don't know what's in the tank. The tank has a valve at the bottom. It's a greenfield site. The site slopes, and Bill, you can correct me if I'm wrong, slopes from west to east. So if this tank was to be inadvertently opened by a child with a soccer ball, football, et cetera, you're going to be leaking at least about 150 gallons of whatnot onto that property. So as I see it, and I'm going to put this back to our board attorney, the safety criteria is up in the air. I feel that this is an unsafe condition. Bill, what's your bottom line answer? Is this a safety issue on the site, based on what you saw today?
Yeah, based on what I saw today, it should not continue in the location that it's currently existing in. I agree with that.
And Counselor, I didn't catch your name, by the way.
It was John Kaplan. I'm from Herald Law in Warren Township, New Jersey, on behalf of the applicant.
Mr. Kaplan?
Yes.
I don't know how we can continue, because most applicants, when they come to this board, they listen to us and they take action and they do things. Unfortunately, by virtue of us being here, by virtue of things being in the wrong place, by virtue of your applicant not paying any mind to what I said at the last meeting about moving this tank, I think we're past that phase. So what's your recommendation here on how we go forward, being that there's 100 some odd gallons of assorted material on property with a valve at the bottom that could be open tonight and leak and flow from west to east into the residential neighborhood adjacent to your client's property?
Our intention this evening was to start with the applicant himself, the owner-operator of the property, to go through the zoning violation that Mr. Bird just...
You have a safety issue, so why don't we start there? Because we don't have to hear your case unless you address all the safety issues.
I do have the applicant here to address the tank, why he has the tank, why every gas station has a tank like that. If the tank needs to be moved, needs to be put on something else, we would like some guidance from the board as to where you want it, because right now, we don't have a building.
We gave you the guidance in March. I told you to move it, you didn't move it, and here we are. And I even did you one more favor, is I had Rich contact your office and said, you should really fix this and not come tonight, which you didn't want to do either. So before someone gets hurt in the neighborhood, and you have 100 gallons plus of chemicals that are flowing through this neighborhood, Mr. Kaplan, what's your plan to fix it?
Our plan is to fix it, but as I was trying to say, Mr. Chairman, every gas station has one of these tanks. Currently, without an approval to reconstruct the building, to put it behind a fence, we don't have anywhere to put it at this moment.
Why would you have a tank with a valve at the bottom that could be opened, that could flood this neighborhood with chemicals? It doesn't make any sense. So whether or not that this is, I'm not an expert on gas station operation, but why would you have a storage tank with a valve at the bottom that's not locked and can be opened? Would you like to see the picture that I took?
I have a picture, Mr. Chairman.
Excuse me?
I have a picture, Mr. Chairman.
There it is.
I have one.
Valve at the bottom. So what are you going to do right now to prevent this from leaking in the neighborhood, Mr. Kaplan?
We would like to put it in a place with a fence around it, if possible, to secure it. But at this moment, we don't have any approvals to construct anything on this site.
When you put a fence around it, how do you prevent the valve at the bottom from leaking the 100-plus gallons of material that are in the container?
I myself am not an expert in gas stations either. I can figure out how to plug the tank. I'm not sure if it's legal. I'm not sure the proper way to.
Why didn't your client move the tank like he was asked and instructed by the board at the March hearing?
He was under the influence that he was just remediating the zoning violations that were issued to him. And it's our understanding, aside from the length of the grass at this moment, that those were remediated.
Was your client in the room at the March meeting?
I believe so.
Did your client hear the board ask him to move the tank?
I don't know. I can't answer that for him.
Okay. Mr. Kaplan, we're going to ask for an extension in time to act on this hearing so you can find a way to remedy the situation. Are you going to grant this board more time? Rich, why don't you take it from here, where we're going with this?
Right now, we have time to act through May 30th, I think, 31st of May. So we would have to look at when the matter could be heard and have some grant of an extension past that date.
That would not be a problem.
So just so we're clear, when you leave tonight, what's going to happen tomorrow on site? Not on Wednesday, or not on Thursday, not on Friday. What's going to happen tomorrow, Wednesday, May 14th?
With your guidance, we will find a way to secure the tank without the valve on the bottom being operational.
I'm not an expert.
Well,
You-
I think
yeah.
your engineer and the board engineer, the township engineer, could come to some agreement on how to safely secure that tank and where.
That's fine. I just need an understanding whether it's just a fence, just a valve, both.
Mr. Burr, what are your thoughts here?
My thoughts at a minimum are that that tank needs to be relocated up onto the paved area where the fueling operations take place, and it needs to be fenced off in a secured area so it can't be tampered with. I have not seen an arrangement like this on other sites. I'm used to seeing something that is more permanent in nature in terms of spill containment, so I haven't seen a tank like this. If this needs to be in operation for the time being to allow the fueling operation to continue, it has to at least be located up onto the paved area and placed in a secured location, fenced off, so it can't be tampered with.
If the contents are flammable, and we're back into the, 'cause that's an operating gas station, I just don't know what to do here. We're not hitting the safe criteria that, it's point number 5 in the zoning officer's letter.
If I may. The reason it is where it is because of the guardrail that's there, which is actually protecting the tank from being hit by any.
Rusty, deteriorating guardrail, correct?
Correct.
Okay, well, it sounds like your engineer and Mr. Burr need to just come to some agreement on how to properly secure the tank and where, and it sounds like Mr. Burr is suggesting be moved to a paved area. Isn't the building area secured now by a fence?
Yeah, that's the one area that I was thinking. I don't know what condition it's in because it had been excavated for footings and it has partial rebar, but there has to be a spot in that area that's already fenced off that maybe that can be placed in there. But got to get on site and look.
I don't want to complicate things, but I do have one question, and that is, do we know what's in the tank, and is it labeled appropriately?
I don't know what's in the tank. I suspect it's not labeled correctly. If you take a look at what the tank, now I don't have.
Because I looked up the label, and it's some chemical solvent that's used to, yeah,
Storage tank, which obviously is not fuel.
right.
Or gasoline, so
So we don't
I
know
don't
what's
know
in
if it's
it,
rated
and we
for-
are pretty sure it's mislabeled. We can find out. You guys know if it's mislabeled?
another
Not
question.
necessarily mislabeled, it might just be a reused tank for that purpose, and previously it was used for something else, but it is a mixture of gasoline and water.
It's a mixture of gasoline and water?
Correct.
Okay. So the labeling it appropriately would be not only recommended, but required and useful if in the event the fire department had to arrive and wonder what it is that they're trying to put out. So mislabeling something that's flammable and that puts the neighborhood in jeopardy is something that just can't stand. So it's got to either be labeled appropriately, located with the help of Mr. Burr, and protected. And I'm sure there's some kind of lockout valves that can be constructed as well in terms of trying to create a safer environment. Also an agreement that this must be a temporary solution, stopgap measure, I'm not sure what to call it, because if you go beyond that and look toward the safe operation of the gas station in the future, and if the applicant's request is approved, then what provisions have been made for the storage of those materials? I don't recall any being in the plans. It's pretty much a convenience store. So I don't know, I'm not going to ask you to answer every one of those questions, but they need to be answered as part of your application.
That's understandable. We will find a permanent location for the tank with the help of Mr. Burr, that it is a safe location and secure.
So we're not even going to discuss future dates until all 5 points on that letter are satisfied. I don't want to take a date away from a resident that's trying to do an addition or another case because you're not in compliance.
Can I have a date for scheduling purposes?
You can do that.
Okay.
So how much time do you think you'll need? So what I would suggest is give yourself some time to be able to relocate this tank safely. We'll give you a date where you would come back just to get a new date, right, for scheduling purposes. So, a month?
My client says he can have it completed within a week to 10 days, so the earliest we can get in for a hearing so that we can get a hearing date at the earliest would be fantastic. If it's in 2 weeks, that'd be great.
May 27th. If they want to come in and prove that they've satisfied it, and then we can give them a date from there, I'm willing to do that.
So by, our next meeting's May 27th. Remember, you have Memorial Weekend right before that, so
Yes.
it's not a full 2 weeks, really.
Okay.
But if you think you can have that relocated and be ready to proceed,
And that's only going to be a meeting where I'll put you first up. You're going to give us a status update. You're going to prove that this is safe. Mr. Burr's going to come in here and say it's safe. And then at that point, we will grant you a night where we can hear this case and continue where we left off.
Understandable.
Uh,
Is that okay, Rich?
yep.
Mr. Burr, you okay with that?
Yes, I am, Mr. Chairman.
All right, any other board comments? All right,
Okay, so then for purposes of the public, with respect to the Germunk Oil application, this matter is concluding for this evening. It will be rescheduled for May 27th in this room at 7 p.m. And as you heard, for the sole purpose of scheduling a new hearing date sometime after that. Okay?
Thank you.
Okay.
Thank you.
Thank you.
all right, before everybody leaves, we have one issue that we have to handle, and that is going to be our 2024 annual report, of which you should have a copy. I know Mr. Fresco had a comment about some fees, maybe a good place to dive in very quickly. Andy, what were your thoughts there on page 6?
You know, I guess I was sort of confused about it, but I think I understand, so I don't know, maybe you could just
Yeah,
give us like a 30
Catherine was kind enough to put this together. Great work. I mean, it was really, we had a good year. heard a lot of cases. Thank you for your diligence on this. And why don't we talk about the $75?
Sure. So, and I have one more follow-up after that, just so I don't forget. So we have what's called, and it's very, I'll say it's very unique to Bridgewater. Not many other municipalities have it, but we have something called a simple variance application. So there's a full-blown application when you're coming in for a site plan, you're coming in for a use variance. The simple variance allows that and they all have fees attached. And there's a fee schedule for each of those types of variances that add up so that there's an application fee for processing that goes to the township, and then there's escrow fees that pay for the professionals and consultants that are reviewing these applications. The simple variance application allows a resident who is coming in under particular circumstances like, like a deck setback, without, like an uncovered deck, there's like a pool, there's like 5 scenarios, and they're very limited. The thing is that it ends up having to go to the board. Regardless of being a simple variance, it's not administratively approved, and so whenever you get to the board, you've got at least 2 professionals looking at it, you've got a meeting night, you've got a completeness review, you've got all this stuff, and so it sounds great in theory, but what happens is we wind up having to replenish that escrow account a lot, and that resident who thought they were coming in with a very low fee ends up getting hit with all these charges. In no way, shape, or form can we avoid it, really. We try our best to try and limit our billing on those because they are simpler and because we can get through them, but just procedurally, it ends up adding up, and then again, it's like walking into a situation thinking you were going to be able to get through this at a very easy cost and then getting hit with all these fees later on, and it kind of dupes. So we've been having discussions, administration has had discussions. It came up kind of as a point of this zoning board application as well, that it would be a way that we could also address it to make the recommendation to the governing body, potentially, if we thought it was okay. It's really in fairness to the residents to say maybe they should know what they're getting up front. The thing about escrow fees is that they get returned if you don't use all of them, so sometimes it's better to get it up front and know what they're getting into so that they want to start the project. But the worst thing that we find out is that especially residential applications get into it and they think, why did I even start this process? This is not what I thought it was going to be, and now I have to pay all these fees, and I'm already knee-deep in it. So we'll figure out the fee schedule. We want to make it fair to residents, but we think that getting rid of this up front would probably be helpful to everybody.
Right, so removing it, because I read it a few times, and then, I reached out to Jeff about it, and I wasn't sure what we're recommending. It's the board recommends the mayor revise, but it's not really, we're not actually saying what they revise it to. It's just, you're saying now remove it.
Yeah, I'd say probably remove that. I think we need to revise our fee schedule anyway.
Yeah.
We probably need to look at that. Right now, that's a separate issue. But that alone, I think, should probably be removed, and we can replace it with something that's more fair, that's better thought through.
Talking to residents, especially obviously the residentials, there is a little bit of buyer's remorse, like what have I got myself into, I think sometimes. And maybe when they have a higher threshold of filing, which includes a higher fee, maybe that would give them kind of the impetus maybe to make different avenues or different conditions instead of just going for the variance, which they think is $75. But
Sometimes they alter the plan to conform.
right. I know, Nancy has given people advice like, well, you can move this around and try this, and maybe you don't need to go to the board. Maybe we can give some incentive to make that happen, because, that's one thing about 2024. We were very busy.
Sure.
But by the same token, though, we had a case recently, a residential case, where there was a de minimis expansion of 200 or so square feet. I think the applicant ended up paying something like between $7,000 and $9,000.
In total escrow. I don't know what they're going to get back, but
Yeah,
it was aggressive.
And like I said, we don't differentiate between our bulk variances and our D variances. It's the same cost. When I said that we need to revise our fee schedule, and it's a separate issue, it's because we have some things lumped together that should probably be separated out. That would make it more fair, particularly to the smaller applications, the
Well,
residential.
should the board be thinking about making a recommendation to the township council and the mayor about treating these differently than we're treating them now?
The case we just heard,
Right.
and the 200-foot deviation we heard, a C variance versus a D variance is a massively different case. It's 20 minutes versus sometimes 2 or 3 hours.
Our fee schedule presently does not differentiate.
I think we need to make that change. I think that's something we should recommend to the governing body.
Mr. Gasky is not here, but he mentioned
He
that
feels strongly about it.
Bound Brook had something when he was on that board that allowed people with these de minimis types of, I want to say almost technicalities that triggers the kind of variance requests that need be made, they had a way of treating it differently.
And I think that's what our fee schedule needs to reflect. Like I said, just from the outset, like one simple thing to see is that a C variance and a D variance are exactly the same cost. That really shouldn't be the case. So I think I can absolutely revise this just to say, generally, the fee schedule should be revisited by the governing, because they adopt it by ordinance, so it should be
And
revisited.
just so the record is clear, we're not advocating for any increases. We're actually advocating for a separation of fees, so a more granular type fee structure.
I think that would be, I would recommend that as well.
All right. Any other board comments? Mrs. Amin?
I have a comment. You know, I want to compliment Christine for this great report. You know, I went through it on the computer very fast, and I'm saying, no one has done so much of analysis in the past like you have done with all these tables and everything. It's really a very nice report. I really want to congratulate you for that.
Thank you.
The bad news is we have 21 and 22 and 23 to still do.
And I was working with Nancy. Unfortunately, she's out right now on
Yep.
leave. We will get to working on those. This was easier for me because I was a part of it. I will definitely get into those as well, so we can get those done as well. So we are all cleaned up on our.
They're coming, so members of the public, they're coming. All right. Great.
And I only had one change, just one minor error on page 2, on the bottom where it's a section on the application summary. The total number of application variance requests was in the narrative says 48. It should be 44, and it's comprised of 29 C variances and 15 D variances. I was just a little off. My table in my Excel sheet was a little bit messed up. And then the table below that, because that only shows the approved ones in the table does not include all of those variance requests. It should be 22 C variances and 8 D variances were approved, for a total of 30.
Got it.
So just a minor update on that.
Rich, do we need formal action on this, or can we just?
Well, you could adopt it with those changes and make the changes, and then it gets sent out.
Okay.
Sure.
And what we'll do is we'll probably have it published on the website. We'll put it on the website.
And that goes down, back to the township council, and,
We'll talk to them. Yeah, we can bring it up to them.
okay, great. Then I'll seek a motion to approve this with the changes that we've mentioned. All right, Mrs. Amin was the motion, and Mr. Waddell was the second.
You can do all in favor.
Yeah. All in favor? Aye.
Aye.
Any opposed? Seeing none? All right, that was quick. Thank you, everyone. Thank you, Catherine, that was good work. Our next meeting, May 27th, 7 PM. We're going to hear the Germunk folks first up. And then, Rich, do you know what we have that night?
I do. We have Belly Holdings, the JCC matter, at 821 Bridgewater matter, and it looks like a residential matter, initial hearing for Mr. Shad. Single-family home on a vacant lot.
All right, so we'll have a busy night, May 27th. Everyone have a wonderful Memorial Day. We have a motion to adjourn. Mr. Rodelli, second. Mr. Seacat, right? Second? Great. Have a good night, everyone. Thank you.